It is April 2nd of 2026, and this is the Court Gallery. Coming up, ladies and gentlemen, we have a compilation featuring 3 judges who've had enough. First, we have Judge Culotta, who's handing down sentences to a reckless driver begging for mercy and an inmate caught with drugs in his cell. Then Judge Hesselink lays down the law with a woman who needs serious help and a defendant who tries to attend court from his bed. But you have to stay for Judge Simpson, who absolutely explodes on an attorney for lying in emotion and neglecting his client. It's a courtroom takedown you don't want to miss, ladies and gentlemen. Grab your popcorn, get a drink, and buckle up. It all starts right now.
We're here today in 2 separate cases, both entitled State of Ohio versus Archer Pekas. Case numbers 24 CR 001250 and 26 CR 000127. Defendant is present in open court. This counsel, Carlos Johnson. We're here for sentencing on both cases. On the 2024 case, the defendant was last before Your Honor on March 6th of 2026, where he waived his right to a probable cause hearing in a final hearing and pled guilty to 6 different rule violations, 1 of count 2, 2 of count 1, rule 8, 9, and 3. In the 2026 case, he was also before Your Honor on March 6th of 2026, where he pled guilty by way of information to 1 count of failure to comply with an order or signal of a police officer, a felony of the 4th degree, 1 count of obstructing official business, a felony of the 5th degree, and 1 count of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the 1st degree. At that time, an updated pre-sentence report and drug and alcohol evaluation were ordered, state's understanding that those were completed and provided to the court, and that all parties are prepared to proceed to sentencing at this time. Thank you.
Thank you. Mr. Johnson, any reason not to go forward with sentencing?
May it please the court, Your Honor, there's no reason not to.
Is there anything you'd like to say at this time in regards to both of these cases on behalf of your client?
Briefly, Your Honor, may it please the court. My client's 26 years of age. He's taken responsibility by way of plea in both matters. He is supported today by his family, his mother, his father, as well as his sister. Your Honor, if you look at the one thing that's common to both these cases, and the common denominator is alcohol. He suffered from this alcoholism probably from an early age when he first had his first OBI at 18. And I think at this point he's had enough time to sit and reflect back on his own behavior and problems, and he's ready to tackle the problem. They say you don't tackle your addiction until you hit rock bottom. And Judge, he's been sitting in the county jail. He had a tumultuous trip from Miami because he got arrested on November the 29th at the airport, and it took him a great deal of time to get back to Northeast Ohio. So he's had a lot of time to sit and reflect and think about his own behavior. What we would ask, Your Honor, I would say this, that prison will be there. It's not the worst form of defense, but it was bad. I can't say, we can't say that it wasn't a bad situation, but we've all seen far worse individuals seated right here. He did work, he paid taxes, he owns property in Lake County. He's going to lose his CDL. That was his means of earning an income. So he's going to have to restructure his whole life. But what we would ask, Judge, is to give him a jail sanction and send him into NeoCap so he can further get a grasp around the treatment that he needs so he can be a productive citizen. Thank you.
Thank you. Pekas, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, Your Honor. I wanted to thank you, Your Honor, for giving me the opportunity to speak in court today. I want to apologize for my actions and for take the full accountability for my behavior. I wanted to say sorry for the community, to the officer involved tonight, and my family being here in court today, my mom, my dad, and my sister. During this time in jail, I have realized what I can potentially lose if I don't change my behaviors. All I can ask is to please have mercy upon giving me my sentence. I know that alcohol was the large factor in my decision making that night and over the last couple of years. I want to receive help for my alcoholism so that I can live a normal and productive life. Secondly, I would like to receive this help in order to keep my CDL because trucking has become my career and something that I love. This help would allow me to stay sober, stay happy, keep out of trouble, and lastly, to keep the career I invested a large part of my life into building and being successful at. Thank you, Your Honor.
Thank you. I'm assuming you knew that by drinking and driving and fleeing from police that you're going to lose your CDL license.
Yes, Your
All
Honor.
right, well, so you knew that and you did it anyway. Now I'm supposed to come to the rescue here somehow?
I was at that night. I think.
No, that answer my question, right? You knew that and you did it. And now, why? Now I'm supposed to do something about that? Well, I can't. Is that important to you? You should have considered that. Why do I need to take that into consideration at this point? You didn't. You haven't considered any rules since you've been on probation with me. You do whatever you want to do. You did that from before we were even convicted the last time when you were out on bond. And we've been dealing with that ever since. Ms. Cutts, on behalf of the state.
Thank you, Your Honor. First, looking at the case from 2024 on the probation violation, this is not a single violation. There were various rules that were violated. This was not his first probation violation. The first one had to do with him having issues in the jail treatment program. He was allowed to go back into that, and it's my understanding he completed it. However, in this probation violation, he didn't report his contact with the Ohio State Highway Patrol to his probation officer. He had additional charges, which are obviously the 2026 case that include failure to comply, as well as obstructing official business and the OBI. He was obviously using alcohol when he wasn't supposed to be on probation. He left the state without permission, and beyond leaving the state of Ohio, he left the country. And he also failed to report to probation for his scheduled appointments. So there are multiple violations, some directly related to the new case, some unrelated to the new case. In the 2026 case, we have a situation where the defendant was drinking. He decided to drive. Then he just decided to drive through a construction work site where the construction workers were actively painting lines. They had to get out of the area, run away so that they would not be harmed. He drove over those lines when he initially pulled over when law enforcement, Highway Patrol got there. The sergeant was speaking with him. Defendant initially denied drinking, had him get out, do some field sobriety tests, had him do a portable breath test. When the defendant realized he was going to be arrested, he ran from the trooper, pulling away from him and running around his vehicle. The trooper ended up tasing him 2 times. When the defendant still got back into his vehicle, trooper tried to tase him again and was leaning into the vehicle when the defendant took off. Thankfully, the trooper was able to step back and was not injured. However, he obviously put the trooper at risk. In addition to this situation in and of itself, he was already on probation for the first case for the attempted abduction, felony 4, and the misdemeanor domestic violence. He does have a history of criminal convictions. It's not a long history, but they are concerning history. In 2017, he has a conviction for his first OVI. It's my understanding he was approximately 18 years of age. There was a high-speed chase and a crash that was involved in that case. And then he has convictions from 2025 for the attempted abduction and domestic violence, where I was involved in that case, and that did involve alcohol as well. He has had some issues while he's been in the jail, creating disturbance, disobeying officers.
That was the first time, though. That wasn't most recent.
That was in the, I would have to look at the dates. In
It was the last spring.
April of 2025. But there have been issues there before. He hasn't responded favorably to previous sanctions. Obviously, this is his second OVI, and he was on probation with his second probation violation. Previously, he has not been honest with the court about his whereabouts when he was on GPS. It's clear that there are alcohol issues based on the last case and this case and his history. However, he has indicated that he doesn't think he has a big drinking problem. I know today he is saying he needs help. However, he spoke with, I believe it was Lisa Friend, on March 24th and was still minimizing, as well as he did in the drug and alcohol she did previously on February 14th. He also minimized to the probation department, and they saw him also in March of this year. He indicated in the pre-sentence report that he regretted his decisions and that he made poor decisions. However, he made a very conscious decision that he wanted to flee the police so that he would be able to see his grandfather. So he decided to break the rules. He may regret the consequences, but that was a conscious decision. Based on all of that, the state does not feel the defendant is amenable to community control. Prison is consistent. There is a mandatory driver's license suspension on count 1, the failure to comply, as well as on count 3. There's also a mandatory fine and mandatory consecutive days for count 3. We do feel consecutive sentences, consecutive service would be appropriate since he was on probation at the time of committing the second offense. And that is the state's recommendation at this time. I would say the credit in 24 CR 1250 is 256 days. Included in those 256 days are the 65 days that he has served in the 2026 case. Thank you.
When was he brought back to our jail? When did he arrive back from Miami? I know he was arrested in Miami on November 29th.
I can check if I have that date.
Well, it'll probably be on whoever the jail list is, right? Actually. That's the first day, so I can check that out then.
He was booked in January 23rd.
January 23rd? It's almost 2 months. Okay. This court has reviewed the original pre-sentence report and investigation that was completed in regards to the 24 case, the updated report that was just completed in regards to the new case, the drug and alcohol evaluation that was just completed. I've considered the facts and circumstances of the offenses involved in each case and nature of those offenses. I considered the defendant's performance on probation in the 24 case. All of his conduct in the 24 case. I've considered what's been said here today. The defendant, his lawyer, the prosecutor, the recommendations. And I've considered the nature of the probation violations. All of this was considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. As for case 24 CR 1250, I'll incorporate all the findings I made throughout that case regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has failed to comply for a second time in this case with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. And in this case, not only is it more likely, one of the violations is for committing a new felony, or new felonies, I should say. So recidivism actually did occur. not just being more likely. Case 26 CR 127, factors indicating the conduct is more serious. The court notes that the defendant was driving through a construction zone when this occurred. He blatantly disregarded the fact that the exit ramp that he was going off of was closed. There were workers actually working at the time. So a lot of times it's a construction zone, but there's nobody there. There were actually people working at the time that you decided to go through the barrels, do what you wanted to do because your exit was right there and you couldn't be inconvenienced by having to go any further to avoid that. The fact that there's actually, it's again a construction zone with construction zone workers working makes it more serious. The fact that you were drunk at the time you were doing it at 2:40 a.m. in the morning makes it more serious. The fact that you had been stunned by the police 2 times and then get in your car and take off after that makes it more serious. The police officer was right there at your car, leaning in when you took off, which puts him at greater risk. That makes it more serious. Nothing makes the conduct less serious. As for recidivism factors, the court finds a history of criminal convictions. In case 26 CR 127, Bennett was on probation or community control sanctions of this court at the time he committed. He was on probation in this court in 24 CR 1250 when he committed the offense in 26 CR 127. Again, he's failed to comply with previously imposed sanctions ordered by this court on multiple occasions. We can go back to the original case when he was on bond, and he violated the conditions of his bond and lied to the court all about that. Then he got violated early on. Then he's been violated now again. I mean, we completely ignored the fact that he left the country while you're on probation, knowing the consequences. You left the country. There's an alcohol problem that relates to the offense, and I don't know if you get it. The report from Lisa Friend says you minimized the whole time you were with her. You minimized the extent of your alcohol issue. That makes recidivism more likely. Fact of the matter is that you're going to do whatever you want to do. You're not going to follow rules. You haven't followed them from the beginning here. You're going to do whatever you want to do. And that's not how probation works. And then you come back later begging for another chance. We've been given multiple chances in this case already. It doesn't matter what I say. It doesn't matter what probation says. You're going to do what you want to do. So the court finds that prison is consistent with the purposes and principles of sentencing in both of these cases. And you're not amenable to community control sanctions. You made that evident. You committed a new serious felony while on probation for a serious felony. You know, a lot of the cases that we're dealing with, people are on probation for, F5 possession drug cases, and they pick up another F5 possession drug case. You're on probation for an offense of violence, an attempted abduction, a serious offense, and you got a nice break with that. Then you pick up these serious felonies, and you should be thanking your lawyer for the fact that this is an F4 instead of an F3, and that he was able to get it reduced. Because in F3, you're facing twice as much time. And the nature of this fleeing and eluding is bad. And getting it reduced, be grateful for that. You got 2 serious felonies that you've committed. Again, prison is consistent with the purposes and principles of sentencing. You're not amenable to community control sanctions. Therefore, it'll be the sentence of this court in case 24 CR 1250. Defendant served a term in prison on count 1 of 10 months in prison. He has credit for 256 days he's served. In case 26 CR 127, it's the sentence of this court that in count 1, defendant served a term in prison of 16 months. On count 2, he served a term in prison of 11 months. On count 3, he served 180 days in jail. Those 3 counts will be served concurrent with each other, but will be served consecutive to the prison term imposed in 24 CR 1250 for an overall prison term of 26 months. There's no credit in the 127 case since that's all been given to him in the 1250 case. Court finds consecutive service between the 2 cases is necessary to protect the public from future crime and punish the offender. The consecutive terms are not disproportionate to the seriousness of his conduct and to the danger he poses to the public, and he committed the offenses in 26 CR 127 while he was on community control sanctions to this court in 24 CR 1250. And quite frankly, the nature of the 2 charges in 2 separate, completely unrelated cases deserve to be punished separately. Case 26 CR 127. It's 2 mandatory suspensions that are required. Suspend your license on count 1 for 4 years. On count 3 for 4 years. Those will be concurrent though, so 4-year license suspension. The mandatory fine required for count 3, I'll impose the minimum $715 mandatory fine. Both cases, defendants ordered to pay all costs. Further need to advise you for both cases, upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Ms. Cutts, is there anything else for the record?
Yes, thank you, Your Honor. In case 24 CR 1250, there is count 2 domestic violence if you were going to put a sentence on that misdemeanor count.
That was a misdemeanor, right?
Correct.
No, I'm not going to impose any sentence on that.
Okay. And then on 26 CR 127, is it accurate to say for the count 380 days that the first 10 days have to be mandatory consecutive?
It can't be consecutive. Oh, consecutive day, not consecutive to their counts. 10
Correct.
consecutive days.
Just that's the
That's
mandatory
fine.
minimum.
I don't want to say it's consecutive to the other counts.
Understood.
It's consecutive days.
In
which
itself.
is already
Correct.
served, really, but yeah. That's fine.
Thank you, Your Honor.
Mr. Johnson, anything else?
Your Honor, would you consider judicial release at some point in time if he shows substantial growth while in the institution?
I just thought of something. Hang on one second. Count 1 has to be consecutive to everything else.
That is correct.
It's unrelated to your question you just asked, but I gotta change it. I mean, it's not gonna be more time, but I gotta change the way it's done. For the record, the flee and eluding charge must be consecutive to any other term imposed, which means it has to be consecutive to whatever terms the court imposed in counts 2 and 3. So the court is going to amend its order I'm not gotten off the bench here yet. On count 1 in 26 CR 127, I'm going to sentence the defendant to 10 months in prison. On count 2, he'll be sentenced to 6 months in prison. Those sentences will be consecutive to each other per statute 2921 331B. And then consecutive to 1250 for the reasons I stated. Plus, it has to be statutorily, it has to be consecutive. So that's another basis for that. So that doesn't alter the ultimate sentence at all, but I just, to make sure it's done the right way, that's the way it's going to be. All right, back to your question. I mean, I always consider judicial release. I'm not going to make any promises or representations at this time. Certainly, we'll be, if that motion's ever forthcoming, we'll be getting the defendant's record of how he behaves in prison and know all that stuff. So he should know that ahead of time. But I'm not going to say yes, I'm going to grant it, but I won't tell you no, I'm not going to grant it. So
Thank you.
the door's open, I guess. But I don't want you going down there thinking you're getting judicial release. But it's not. You have don't want you thinking it's not a possibility, I guess. Anything else?
No, Your Honor.
All right, thank you.
State of Ohio versus Zachary W. Robinson, case number 26 CR 000324. Defendant is present in open court today with his counsel, John Patika. Your Honor, we're here on a 4-count indictment that was filed on March 16th of 2026. It is the state's understanding today that the defendant will plead guilty to count 1, possession of cocaine, a felony of the 5th degree with forfeiture specification, as well as count 3, violating a protection order, a felony of the 5th degree. At the time of sentencing, counts 2 and 4 would be dismissed. It's also the state's understanding the defendant wishes to proceed to sentencing by either waiving a pre-sentence report or incorporating the previous pre-sentence report that was completed. There's no sentencing agreement, and that is the state's understanding at this time. Thank you.
Mr. Patika, does that sound accurate? I will incorporate the prior PSRs for reference purposes. So, but
Thank you, Your Honor. That's my understanding.
thank you. Mr. Robinson, were you able to hear what the prosecutor had to say regarding, and your lawyer, regarding what they believe your intentions are here at this time?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of guilty to counts 1 and 3. Plead guilty to those charges. Counts 2 and 4 would get dismissed. We would then proceed to sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor? Most importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you any questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Well, let's get started then. How old are you, sir?
I'm 43 years old.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before coming into court here this morning, have you any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
No, Your Honor.
Now, you should have been served with a copy of this indictment. It was probably just a couple weeks ago at the most. The document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes, Your Honor.
And at some point, did you have the chance to look at that?
Yes, Your Honor.
Now, in that indictment, you are charged with 4 counts. You're pleading guilty to 2 of those. The first count you're pleading guilty to, count 1, alleges on or about January 26, 2026 in Painesville, Lake County, Ohio, that you didn't knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. That conduct constitutes the offense of possession of cocaine. It's a felony of the 5th degree. You understand what you're charged with and pleading guilty to in count 1?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
There's also a part of this count that's called a forfeiture specification, which alleges during the commission of the offense you possess or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal, just by the nature of the property itself, like drugs. an instrumentality is some type of property that there may not be anything illegal about it in and of itself, but it's being used in an illegal manner to facilitate a crime. And in this case, there's the cocaine, there's buprenorphine, and packaging. The whole point of this is that you just forfeit any ownership interest you may have in that property. It doesn't increase any potential penalty or sentence you face, but it allows the prosecutors to be able to dispose of the property once the case is over with. You understand what's alleged there?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, in count 3, what is alleged and what you're admitting to is on or between January 1st and January 31st of 2026 in Paynesville, Lake County, Ohio, that you did recklessly violate a term of a protection order that was issued pursuant to 2903.213 or 2903.214 of the revised code. It's further alleged that you have previously been convicted of or pled guilty to one or more violations of violating a protection order, that being the Mentor Municipal Court, back on February 17th of 2021. That conduct constitutes the offense of violating a protection order. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 3?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, there are 2 other counts of this indictment that are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Any questions about any of those 2 charges?
No, Your Honor.
Well, then before I can accept your guilty plea to the 2 counts I just read to you, I need to make sure you understand all the rights you are giving up. And you first of all have the right to have a trial. Now, that trial could be to me as a judge, or I listen to all the evidence and then I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be unanimous, which means all 12 jurors would have to agree together one way or the other as each charge whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. By having the burden of proof, what that means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of the charges, and the presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, I talk about this burden of proof since it's a criminal case that we're dealing with here. That burden of proof is called proof beyond a reasonable doubt. It's the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state has presented at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, if we were going to have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. We call that cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have the right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. That order we call a subpoena. What a subpoena would actually do is force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right of trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then, that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. The court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you've given up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
You understand a guilty plea is a complete admission of guilt. It means you're going to be admitting to the facts being alleged in these two charges. We're not going to argue later you didn't do this or it's someone else's fault or blame, anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you'll subsequently be sentenced by the court. Do you understand that?
Yes, Your Honor.
And as far as sentencing goes, count one, the cocaine charge carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Count three, the protection order carries with it, it's a felony of the 5th degree as well, and also carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, since these are two separate charges, unrelated, if I impose a prison term, I impose it on each count, and then as a judge, I had the discretion to run those prison terms concurrent or consecutive to each other. Concurrent means you'd serve the prison term on each count at the same time. Consecutive means one after the other. You'd serve the prison term on count one, whatever it was, finish that, then serve the prison term on count three. You understand the difference there?
Yes, sir.
So in this particular case, if I give you the maximum sentence on each count and ran them consecutive, you're looking at a maximum possible prison term of 2 years in prison. You understand that?
Yes, Your Honor.
Now, I think I know the answer to this, but let me just answer. Are there any other charges pending against you anywhere?
No, Your Honor.
I'm aware that you're obviously serving another prison term, 2 other prison terms right now. I need to advise you that if a prison term is imposed in this case, I also do have the discretion to run that prison term concurrent or consecutive to the terms you're currently serving. Again, concurrent means you'd start it and serve it while you're serving those other terms. Consecutive means you have to finish those other terms, and once those are completed, then serve this sentence. You understand the difference there?
Yes, Your Honor.
Now, if a prison term is imposed in this case upon your release from prison, you could be placed on post-release control, sometimes referred to as parole or PRC. It's a period of supervision you would be on after you completed the prison sentence. In this case, it's not mandatory. It's up to the parole authority to decide that, but it could be up to 2 years. You understand that?
Yes.
And if you were on post-release control at any point, never violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Let me see one thing. Now, aside from the possible prison sentence, there are other sanctions that could be ordered. You could be fined in this case on each count. It carries with it a possible fine of up to $2,500, so therefore is a maximum fine in this case of $5,000. I could order that you pay court costs. I could also order that you reimburse the county for any costs of confinement. community supervision or treatment if any that were applicable. Do you understand that?
Yes, Your Honor.
Count 1 also carries with it a possible license suspension of up to 5 years. Do you understand that?
Yes, Your Honor.
And also, as I alluded to earlier, the forfeiture specification means you'll forfeit any ownership interest you have in that property. Do you understand that?
Yes, Your Honor.
Now, I just advised you of the possible prison term. I used the word possible because technically you are eligible for probation on these charges. That doesn't mean it would be granted, but it means technically you're eligible for that. Do you understand that?
Yes, Your Honor.
Now, when we proceed to the sentencing hearing, you're going to have the right at that time say whatever you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, I do not, Your Honor.
You understand all the possible consequences?
Yes, I do, Your Honor.
You still want to plead guilty?
Yes, I do, Your Honor.
Have you had enough time to talk about this case with your lawyer and have him review the report with you, discuss the issues, and answer whatever questions you may have?
Yes, I did, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes, I am, Your Honor.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, I have not, Your Honor.
Are you entering a guilty plea freely and voluntarily?
Yes, I am, Your Honor.
All right, then. Do you have any questions for me at this time regarding anything we've talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, I do not, Your Honor.
Do you need any more time to talk with your lawyer before we go forward with the actual plea?
No, I do not, Your Honor.
All right, then what's going to happen at this point is the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her because then I'll have some follow-up questions for you. I know it's two separate instances. Do you want to do them at the same time or do you want to do one at the same time?
I figured I would just go
Okay.
in chronological.
Go ahead. So make sure you listen to what she says.
Yes, Your Honor.
Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that in case number 25 CS 001682 in September of 2025, a civil stalking protection order under 2903.214 was granted for Nicole Knapp against Zachary Robinson, the defendant. He was initially served on September 16th of 2025. Then at the final hearing on September 22nd of 2025, the parties agreed to the protection order, which was put into place until September 8th of 2030. The defendant was in the Lake County Jail in Painesville, Lake County, Ohio, during the month of January of 2026. During that time frame, he contacted people through phone calls and text messages to give messages to Nicole Knapp, one of the protected people under the protection order. He would ask them to send messages through text or conversation. He also has a prior conviction for violating a protection order out of the Mentor Municipal Court, case number 20 CRB 00431, which is dated February 17th of 2021. Also, while in the jail on January 26th of 2026, Lake County Sheriff's Office deputies were notified by jail staff that while at the jail on East Erie Street in Painesville, Lake County, Ohio, they had located what they believed to be narcotics in the cell of Zachary Robinson, the defendant. There were two folded or unfolded small pieces of paper that contained white powdery substance. They were found during a shakedown in the cells on the back of a calendar or menu hanging on the wall in the cell that was only occupied by the defendant. Initially, the defendant indicated he had no knowledge of the contraband. It was sent to the Lake County Crime Lab, and it was found to contain in one packet cocaine, Schedule II controlled substance, and in the second packet cocaine and buprenorphine, the cocaine being Schedule II, buprenorphine being a Schedule III controlled substance. When detectives from the Lake County Sheriff's Office spoke with the defendant, he initially denied knowledge of the substance, but then later indicated that he had gotten it from another inmate in the jail. He believed he was purchasing gabapentin, which he snorted part of. He received the gabapentin, what he believed to be, in exchange for a Snickers candy bar that he was able to slide under the cell door. He indicated he had snorted half of it and then had saved the rest by hiding it behind the calendar in the cell. All this occurring in Lake County, Ohio, and that would be the state's evidence.
Mr. Robinson, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial in this case?
Yes, Your Honor.
And what, if anything, do you have to say about those facts regarding each of these 2 counts? Are they true? Did you do what you said?
Yes, Your Honor.
Very well, then regarding count 1, charging with possession of cocaine, a felony of the 5th degree at the forfeiture specification, what is your plea to that?
Guilty, sir.
Regarding count 3, charging with violating protection order, a felony of the 5th degree, what is your plea to that?
Guilty, Your Honor.
All right, I have in my possession at this time a 4-page document called the Written Plea of Guilty and Judgment Entry, which sets forth everything we've just talked about. Before I can accept your plea, I need to make sure you understand the document and you sign it here in open court. My understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Fatigue, is that accurate? Did you review this with Mr. Robinson, go over it with him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did, Your Honor.
Is that correct, Mr. Robinson?
Yes, Your Honor.
So you understand what this document says?
Yes, Your Honor.
You have any questions for me about it?
No, I do not, Your Honor.
Now, it also appears you signed the document. Did you sign it?
Yes, Your Honor.
Mr. Fatigue, you witnessed that?
Yes, Your Honor, I did.
Let's cut you as well.
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, found the defendant guilty of count 1, possession of cocaine, a felony of the 5th degree, in violation of 292511 of the revised code with the forfeiture specification, and count 3, violating protection order, a felony of the 5th degree, in violation of 2919.27A2. I will dismiss counts 2 and 4 at this time as agreed upon between the parties. As I said, I will rely on the PSR that was previously done. Mr. Pekas, is there any reason we should not go forward with sentencing?
No, Your Honor.
Is there anything you want to say on behalf of your client?
Yes, Your Honor. I'd like to highlight the fact that Mr. Robinson is serving his first prison term that was imposed by this court of 2 years. Having been to the institution, he now has a greater understanding of consequences. He is undergoing counseling while at the institution. 43 years old. He was a roofing contractor for 23 years prior to being locked up. He understands he used very poor judgment to continue to have contact with the victim in this case. He's a 2001 graduate of Harvey High School. In my conversations with him, I've stressed that he's not to have any contact. I believe that he understands that. I'd also like to highlight the fact that he accepted responsibility at the earliest stage. We had a free trial earlier this week, and we're here with a change of plea in his sentencing a few days later. Based on all that, we'd respectfully request the court consider imposing concurrent term. Thank you, Your Honor.
Mr. Robinson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor.
I did receive a couple letters from you this week, and I've read those, but you can say whatever you'd like to say here as well.
Okay. First, I would like to apologize to you, Judge Culotta, and the courts. When I was in jail, I was in a very dark place, going to prison for the first time, and losing the love of my life to Clay was very hard to handle. Now that I'm currently in prison, I have time to think about my actions, and I deeply regret them, and they will never happen again. Please give me the opportunity just to finish the 17 months I have in front of me with no more. I've had 0 behavior issues or tickets, and I'm finally getting the correct mental treatment I need through the psychiatrist there to get my obsessive compulsive disorder figured out. Please and thank you. Then I know I messed up really bad. This will never happen again. My daughter's 14 years old. She needs her father, and also my dad, who's in the courtroom.
Why don't you think about that stuff? Why do I have to think about it? Why do I have to take that into consideration?
Right.
You're not. You're sitting in over there scheming and planning and finding ways to subvert this court order, knowing that if you get caught, you're going to be taken away from your daughter, you're going to be taken away from your dad, and you're doing it anyway. Right. And then you come to court saying, Judge, can you take into consideration my daughter and my father? Because I don't. That's not right.
Right. And that's what I have to start thinking. Like,
let's talk about, you claim that you don't have any tickets in prison.
No, Your Honor.
Well, that's not true. Now, they may not be serious, but I've got your prison report right in front of me.
I have a ticket?
You've gotten 2 verbal warnings for violating rules.
Oh, okay. All right.
Right?
I just didn't know.
From the same day?
I didn't know those were tickets.
Well, I don't know what the definition of a ticket is, but you've gotten written up a couple of times, but twice in the same day for... Again, it's minor. I'm not saying this is something serious. You're in the wrong bunk. You're in someone else's bunk when you're not supposed to be there. You guys switch bunks. You've got someone else's shirt you're wearing or using or possessing. But nonetheless, it was a disciplinary infraction that you committed, and it resulted in 2 guilty infractions, and we got verbal warnings on both of them.
Okay. Understood. I didn't know those were something that's... I'm new at this.
It was part of your disciplinary history. I mean, you talked about this last time. Did you think you're smarter than everybody and that you could say things and do things and we're not going to find this stuff out? Well, I didn't mean to cut you off. If there's more you want to say, I don't make sure you say everything you wanted to say.
No, I just... There's no excuse, and you're right about the things you said, and I do apologize, and I just got to start thinking better, and I got to get the mental help that I need, and I apologize.
Okay. Mr. Fatigue, anything else on behalf of the defense?
No, thank you, Your Honor.
It's cuts for the state.
Thank you, Your Honor. As this court is aware, we are back on a 3rd case. These cases have all been back-to-back, all of them regarding or connected to activity involving Nicole Knapp and not leaving her alone. The initial case, there was not a protection order in place, but she did get one, but that did not stop it. He has continued through 2 other cases. He continues to ask others to contact her while in the jail through calls and texts, dictates messages, has his daughter do that, has other people do it. Some of them tell him, no, I'm not going to do that. Some don't say if they will or not. He's contacted her family members to be included in trying to make contact, which has continued through calls and text messages. So though Ms. Knapp did not submit another victim impact statement, she initially had submitted one and felt that the court has been involved and has known the progression and what has been going on. So this does continue to create serious psychological harm in the contact and the contact with her family, and obviously the relationship facilitated the offense of violating protection order. As this court has alluded to, the defendant does try to be sly about it. He'll use different names, try not to say her name, different things of that nature. And then we also have the possession charge where while in the jail he purchased drugs to use them in the jail and used part of them before hiding them. All serious aspects. He does have a history of criminal convictions, and he has one juvenile adjudication in 2000. I won't go through all the adult convictions. The court is well aware of them, but there are a lot of drug convictions beginning in 2005. First felony offenses appear to be in 2011, and then in 2013, where there were probation violations. There was assaultive behavior in 2020, telecommunications harassment in 2020, violating protection order in 2021, assault and menacing in 2023 with probation violation, escape in 2024. And then the cases that this court has heard in 2025, he was convicted of the telecommunications harassment, where there were thousands of phone calls made, and the menacing by stalking as a misdemeanor, where he was sentenced to prison. While waiting on sentencing for that case, he committed the 2026 conviction case, menacing by stalking, felony of the 4th degree, and violating protection order, felony of the 5th degree. He was sent to prison in that case. While that information was pending is when he had the drugs in the jail. He was then sent to prison on that case, and now we are here on this case. So there's been a continuation. As he's dealing with one case, he gets a second case. As we move on to the second case, he gets a third case. Based on all of that, we do not feel that he is amenable to community control, that prison is consistent, and that consecutive service and sentences would be appropriate. Again, he was awaiting the plea and the sentencing in 26 CR 007. The information had already been filed, and he does have a history of criminal convictions, which would make that appropriate. There's the forfeiture specification as well. He has no credit because he was serving sentences, and that would be the state's recommendation at this time.
Thank you. This court did review the prior pre-sentence report and investigation. I've taken into consideration the nature of the offenses involved in this case, the circumstances surrounding that. I've considered what's been said here today by the defendant, his lawyer, the prosecutor, the recommendations. I have received a couple prior lists considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, same stuff as in nothing stands out there in terms of making it more serious. It's the same as he's always done. Recidivism factors, and again, it just continues. The defendant's got a history of criminal convictions. The history actually goes back over 20 years. Over the last 6 years, he's got a violation of protection order, telephone harassment, menacing, telecommunications harassment, violating protection order. All within 5 years, there's just multiple offenses and conduct of a similar nature, and just keeps doing it. And doesn't matter, and they're all involve violating orders. Doesn't matter what anyone tells them. So he's got a prior criminal history. He has failed to comply with previously imposed sanctions ordered by courts. There's multiple probation violations before his past as well, when he was given a chance on probation. This offense was committed while he was serving a prison term for the same type of conduct, and while new charges were pending against him for similar type of conduct. It didn't matter. Those are all factors indicating recidivism is more likely, and it just continues. Nothing indicates recidivism is less likely. In 29-13B1, and the defendant was serving a prison term at the time it happened. Prison is consistent with the purposes and principles of sentencing. The defendant's not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that on counts 1 and 3, defendants serve a term in prison of 11 months on each count to be served concurrent with each other. But there's no reason why should you get concurrent time? Why, if I give you concurrent time, there's zero punishment or recognition for what you did here. Zero. And you're serving a prison sentence, you have charges pending against you, and I'm just supposed to ignore it. That's not how it works. If you're going to make the conscious decision to go ahead and continue to engage in this conduct, then this is what's going to happen. We're going to come back here and you're going to get more time. You're going to add it on and on and on. You know that. You got to take into consideration, take that into consideration before you continue doing it. And you do, and you decide you're going to do it anyway. Because you think you're smarter than us, like I said before. You think you can use all these tricks or, use fake names, have meetings and tell people you're going to refer to people as different names, set things up, and that nobody's going to catch you. Well, you're going to get caught every single time. So there's no reason whatsoever that I can come up with to give you concurrent sentence, because then it just ignores the fact that you just said, screw you, judge, screw you, courts. I'm going to continue doing what I want to do, and it doesn't matter what you do to me. So this sentence is consecutive to the prison terms you're serving in 25 CR 1364 and 26 CR 007. Consecutive services of these terms are necessary to protect the public from future crime, which is going to happen. You've demonstrated that. Also, to punish the offender. They're not disproportionate to the seriousness of his conduct and the danger he poses to the public. And the court finds that an information was pending, waiting trial plea on that when this was committed. He was serving a prison term when it was committed. And his history of criminal conduct, especially of the exact same nature, demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. And as much as the sentence is consecutive, there's zero credit for this case. I need to advise you, upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate those conditions, the parole authority could send you back to prison as punishment for violating the rules for another, in this case, 5.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transitional control, or TC. You're ordered to pay all costs, and I'm going to order the forfeiture of the contraband. Counts 2 and 4, I think I already dismissed them, but those are dismissed. Ms. Cutts, is there anything else for the record?
No, thank you, Your Honor.
Mr. Fatika.
No, thank you, Your Honor.
All right. All right, next matter is State of Michigan versus Serena Weber, file 25-6868-FH, set for a sentencing.
For the record, Michael on behalf of the people.
James Dick on behalf of Ms. Weber, who is appearing via Zoom, Your Honor. And Ms. Weber consents to being sentenced via Zoom today, Your Honor.
All right, I do see her via Zoom now. Looks like I've gotten just today a report from Catholic Human Services. And looks like some letters or a letter in support. Give me a minute just to familiarize myself with that. Mr. Rolla, have you gotten a copy of that as well?
Yes, we received it this morning. Thank you.
Mr. Dick, have you gotten that as well?
Yes, Your Honor. I sent it over.
All right, thank you very much. I assumed that, but I didn't want to not ask. All right, I've had a chance to read the report from Catholic Human Services as well as the letter of recommendation from Rayanne Salem, and then the report from Dr. Atara Abramsky involving her or the evaluation for criminal responsibility and also recommendations as to potential treatment. Let me then return to the basic information report. Either council have any additions, corrections, or deletions that need to be made to the factual bases and the rest of the report?
Not on behalf of the people. Thank you.
No additions, deletions, or corrections to the PSI, Your Honor. No objections to the guidelines. The only challenge the defense would have, or pardon me, request would be that the court deviates from the recommendation a little bit, but that's all.
All right. I would note that the Mr. Rolla, any issues as to scoring of the guidelines?
No, Judge, we don't object to the scoring. We believe it's been properly scored.
All right. I would note that under the offense variables for OV10, there is no points given for exploitation of a vulnerable victim. That would be potentially the son based on youth and authority status. Mr. Rolla, do you believe that that's appropriately scored to 0?
In this particular case, under the circumstances, as I understand it, that the son actually physically put out a number of attempted earlier fires and continuing fires, I don't know if he'd actually be called as a vulnerable person, especially in light of the fact that, as I also understand it, the defendant directed that he leave the premises before she continued. So yes, I believe it's properly scored under these specific factual circumstances.
All right. Then I will accept the scoring. It is at a level of C2, which puts the guideline minimum range at 0 to 17 months. All right, then I will ask for allocution first of prosecution, then of Mr. Dick for the defense. And then I will ask for the defendant to make any allocution she wishes to do as well. So Mr. Rolla, your comments?
Yes, thank you very much. In regards to the additional information, especially as to the secondary assessment by Atar Abramsky, I would ask the court to take note of a few things. One of which is that there's little or no question that this defendant has had mental health issues in the past. However, it's the people's position that it should not be an excuse to behavior, even though there was no such finding under criminal responsibility or legal insanity. But even as to a lesser degree, it's not an explanation, much less an excuse, when persons who know they have mental health disorders don't take their medication as prescribed, or as in the instant case, they, instead of taking their prescribed and doctor prescribed medication, they use street drugs such as methamphetamine. That does not excuse the behavior in any way, shape, or form in the people's position. The only additional thing I would add to the court is, as the court's well aware, under the Crime Victims' Rights Act, specifically under the definitions of a victim under MCL 780-752 definition section, victims include any organization or agency that provides reimbursement, etc., or coverage for the victims. That would include in insurance companies and insurance carriers. And in this particular case, the insurance carrier has requested reimbursement in the amount of $1,864.75. I'd ask that the court include that in any particular judgment of sentence. I'd also point out to the court that at the time of this, which creates a greater concern, the defendant was on a deferral for a possession of meth case as well. I think the court needs to take that into consideration, especially from what I've heard now is the defense is asking the court to go below the guidelines or make a deviation, in which cases the court's also well aware you need to make specific findings of fact to justify doing so. I don't believe they apply in this case. Thank you.
Mr. Dick, your allocution?
Yes, Your Honor. First of all, yes, Miss Weber, she's been dealing with mental health problems for a very long time. She had a period of time where she thought that things might be somewhat under control, and they crept up and got her. She did address them improperly, as is regularly seen, which I think the court can take judicial notice of. People with mental health problems often find themselves abusing substances of one manner or another. In this particular instance, Ms. Weber that was not consistent with somebody that was fully of rational thought at the time. As Mr. Rella mentioned, she did direct her the burning activities in her home. For somebody to potentially be trying to burn a house down with themselves inside and with their child inside, that does beg for some help with mental health issues. Did we just lose the court?
I did momentarily, but got him immediately back, Mr. Dick.
Oh, all right. I don't see the judge anymore.
I don't either. I can hear you, and I don't see the court at the moment.
Because the host is still here.
Oh,
One moment, let me figure out what's going on.
sure.
I just had a power surge and it keeps going off and on.
Yeah, I do too. I'm at the Quality Inns close to the courthouse. Maybe that's what it is.
Yeah. I just lost power. So I'm running on battery.
Well, the ice is slowly melting off of my windows here, so hopefully it's quick and the power comes back on.
If it's any consolation for a change, our office didn't lose power.
That is a change.
We lost power partially. They are working on it. They should be back on shortly.
Thank you.
If I, Natasha,
Yeah, Larry.
if I get cut off or don't show up this afternoon, it's because I lost power
Okay, I'll let them know.
and my battery died.
Okay.
Sorry about that, everyone. The court experienced a power outage to half the building or at least half the courtroom, so it took us a minute to get back up and running. All right, we're back on the record in the matter of Serena Weber, file 25-6868-FH. Mr. Dick, I believe that you were beginning your allocution, so if you'd start over again, please, sir. I'm sorry, Mr. Dick, you're on mute at the moment.
I'm sorry, Your Honor. Would you like me to continue from where we left off? I believe I stopped as soon as I saw you go out.
Yes, please.
Okay. So, Your Honor, Ms. Weber's been addressing these underlying issues and has been successful outside of a brief period of time where few offenses occurred over a few month period. She has been continually in therapy. She's been attending NA. She's been in group therapy. She's taking her medications as prescribed. She starts with a new psychiatrist here in a couple weeks. And just in dealing with all of this and fighting to maintain her sobriety and sanity, she has found herself with 4 hospitalizations during the time period that these few incidents occurred. Now, this particular incident, she had not yet been sentenced on the other matter that she is currently on district court probation for, the 7411 case, Your Honor. That one, I believe, was sentenced June 20th, if I'm not mistaken. But nonetheless, the offense date on this offense was April 16th of this past year. So she had not been placed on probation at that time.
Mr. Dick, my staff and my personal memory is that she is on probation or was on probation already in that file.
Right.
In April?
She was placed on probation May 1st.
Currently still on probation.
Okay,
Right.
May 1st. All right, I made a mistake. I misstated the dates. Pardon me. The even being placed on probation May 1st. The PSI shows that there was a plea on May 1st, and the disposition date was June 20th for the matter that she's currently on probation for. And the other matter, that this particular one that we're dealing with here, reflects an offense date of April 16th of 25. And she was ultimately arrested on June 24th on that matter. I just was trying to clarify that so that she doesn't reflect that she was on probation at the time of the offense. She was definitely on bond.
All right, go ahead.
So, and with that, this was the date of this offense was one of the times that she did spend a week in in residential treatment for her mental health, underlying mental health issues. And since the incident, Your Honor, she's been in some sort of therapy with Catholic Human Services. She was attempting to get into some additional therapy with community mental health, but that was something that she was having some ongoing issues with, which have since been resolved. She's taking medication as prescribed. She is doing everything that she is supposed to. And as the report from Catholic Human Services reflects, as the early January report from Dr. Abramsky reflects, it is all saying that Ms. Weber needs something that focuses on her mental health and substance abuse, and that jail would likely be inconsistent with her continued recovery and support. So what we are asking here, Your Honor, as the court's been able to review the documents that were submitted, the letters and whatnot, we would ask that the court just considers adopting the probation portion of this, as Ms. Weber has been performing rather well in general since these incidents, and any term of incarceration would likely impede her continued therapy. It would affect her mental health in a negative manner. And again, I'm just going to leave the court with that she has been performing rather well in general since these incidents.
Thank you, Mr. Dick. Ms. Weber, is there anything that you want to tell me before I decide what to do?
Your Honor.
What do you think that you need to do to stay on the straight and narrow?
To continue my therapy and outpatient services. Work. When I work, I'm not busy, or I don't have free time to mess up. I don't know.
What stopped you from doing that before?
There was a medication change with my meds. That's why I've been trying to get into a psychiatrist, because my PCP doctor doesn't have the knowledge to manage my medication.
Then why in the world would you think that meth would help?
At the time, I had gotten with my ex-boyfriend, who introduced me to it.
These mental health issues are nothing new for you, are they?
No.
Then you've got to know that street drugs of any kind are what the doctors call contraindicated, meaning they're really, really bad for you. And it sends you into a tailspin like this is faster than you can react to it. You've got to know that, right?
Correct.
So what's different now? Why do you think, why should I take a chance on you going back out into public and going through the same mess all over again?
Because I'm staying away from anything drug-wise. I changed my whole life around. I don't associate with the people I used to associate with. I've been passing all of my drug tests through probation. I've been working really hard to stay on the straight and narrow.
Dr. Abramsky, in his recommendation, says that you would required to participate in a structured treatment plan in conjunction with strict supervision and benefit from placement in a long-term integrated dual diagnosis treatment program. I haven't heard that you're in one of those right now, or that you're even actively applying for one of those right now. What can you tell me about that?
I was scheduled to go into one, and I had another breakdown and left Bear River to go to the behavioral health unit in Sheboygan. And then I was planning on going back into a rehab facility, but my house was foreclosed on and I had to pack up my house and find a place to live.
Mr. Dick, are you aware of any long-term integrated dual diagnosis treatment program that she qualifies for?
Yes, I know a couple of them, Your Honor.
Is she available to go into them soon?
Yes, they would have availability. Of course, it would be up to her to agree to do so.
Well, I got to tell you this, if she's not going to go, I know where I'm going to put her.
Okay.
Are these local facilities that you have in mind, Mr. Dick?
One of them, Your Honor, that I generally make referrals to is the Lion's Den, which is a 8 to 10 month residential program, which after that has an additional component to it if you successfully graduate. Another is a longer program that is not local. It's actually down in Pontiac, but it's Grace Centers of Hope, which has a initial 12-month component. And if you successfully complete that, they have an optional 24-month component to it that pretty much sets people up for life if they put in the work. Although both of these are Christian-based programs, so that would also have to be something that Ms. Weber is willing to accept.
You ready? You ready to do one of those programs, Ms. Weber?
Yes.
That didn't sound like a wholehearted yes.
No, I am ready.
Well, in what way are you not ready?
I don't really have an answer for that.
I'll make it really easy for you. Go to jail or go to long-term treatment. Which would you like to do?
Long-term treatment.
Excellent answer. I can't have you in public using meth and burning down houses where your kids were in it. Do you understand that?
Yes, Your Honor.
I get it that you've got some issues, and I get it that it's long-term, and I get it that it's hard. but I can't have you killing yourself or killing your kids simply because you won't go get the treatment that you know that you need, and you're substituting meth for treatment. That's just not going to work, and I'm not going to let it happen. And if I have to lock you up to do that, then I'll do that. At least I know you're safe there. I would prefer that you get some long-term treatment so that when you get out, you don't have the likelihood of repeating the process all over again. Does that make sense to you?
Yes.
Still makes me wonder why you haven't wholeheartedly said yes to this yet, but I guess I'll give you some time to work on that. I'm going to put you on probation for 2 years as opposed to a year and a half, because I think you need the time to figure it out. While you're on probation, you may not use alcohol or possess alcoholic beverages. You may not enter bars or other places where the primary purpose is to serve alcohol. You'll be involved in alcohol testing. Must not attempt to do any fraudulent or adulterated samples. May not hinder, obstruct, tamper, or otherwise interfere with testing. And you must provide proper identification. Same thing goes for drug testing. You may not possess or use any controlled substances or drug paraphernalia. You must complete an outpatient or residential substance abuse treatment program. I'm going to say dual diagnosis. And that's going to be the Lion's Den in Roscommon or the Grace Center of Hope. Where was that located again, Mr. Dick?
So that one's out of Pontiac, Your Honor. And
in Pontiac. So you can choose either one you'd like, but you got to get in one of those two. Must take your medication as prescribed. Must complete mental health recommended treatment. Must obey all court orders. Must not engage in any assaultive, abusive, threatening, or intimidating behavior. May not have verbal, written, electronic, or physical contact with anyone housed within MDOC, or be engaged in any behavior that constitutes a violation of any criminal law. May not use any object as a weapon. May not own, use, or have under your control anything that could be used as a weapon or be in the company of anyone who is. Must comply with the written and verbal orders of your field agent. Must allow the field agent into your home for supervision purposes. Must submit to a search, including vehicle and residence and computer without the need of a warrant if the agent has reasonable cause you violated conditions of your probation. You must report any arrest, police contact, loss of employment, or change of residence within 24 hours. Find and maintain legitimate employment when you're not in treatment. I'm going to give you 6 months in jail, hold 6 months in abeyance. That means you don't have to do any up front, but you must get into that long-term dual diagnosis treatment center, or I'm simply going to require you to do the jail time. There is a crime victim assessment of $130. It's a $30 per month supervision fee. Court costs of $325. Attorney fees of $350, $68 court costs, and you may be detained for up to 72 hours for any alleged violation of probation. Do you have any questions as to the order of the court, Ms. Weber?
No, Your Honor.
Mr. Dick, any questions?
one, Your Honor. In the instance she wasn't accepted for whatever reason, and this is just to make sure that she has possibility to do something that the court's ordering, would she be permitted to enter any other programs that, well, I may be able to present to the court on her behalf, such as the Odyssey House?
Let's do this. I want her to get in the next 30 days. So I'm going to set a review hearing in 30 days. I'll call it a probation hearing. It'll be solely on the issue of where she's going and what agency she's going to get into. And you can certainly raise that. If she's not in either the Lion's Den or the Grace Center of Hope in 30 days, I need to see some movement as to where she's applying to and how much effort she's put into it. I'm not going to just give her an out if she says they didn't accept me and I didn't do anything. Then I'm going to put her in jail. So she's got to show me effort to get in a place within the next 30 days.
Judge, as a housekeeping matter, I have a question.
Yes.
Not to put too fine a point on it though, but when the court orders complete the program, I assume the court means successfully complete the program. So if she's discharged or violate the rules, she's to return to someplace else.
That will be the jail.
I just wanted to give the defendant the incentive to know that that's what she's looking at. Perhaps that'll help her follow the rules. Thank you.
Thank you, Mr. Rolla. Any other questions that you have, Mr. Rolla?
No, I do not. Thank you very much.
That'll be the order of the court then. Thank you very much. Good luck to you, Ms. Weber.
Judge, can I have a
Go
question,
ahead.
sir? In the beginning, you guys talked about money to the insurance company. Is that being ordered as restitution?
Thank you very much. I appreciate that. Yes, $1,864.75 in restitution to the insurance company. I didn't think I imposed, well, I did impose the fines and costs that were recommended.
Do we know the insurance company, what insurance company that is?
Yes, we do. Hang on. I'll pull it up.
Susie, I can send you the order.
Okay, thank you. And then does she get 6 days credit, Judge?
Yes.
Okay, sir. Thank you.
Thank you very much for keeping me on task. All right. Ms. Weber, do you have any questions?
No, Your Honor.
All right. Good luck to you. I hope things go well for you. Please do your best to do what is required. Thank you.
Thank you.
State of Michigan versus Joseph Erky, file 25-43937-SD, set for sentencing. Are you Joseph Erky?
Yes, I'm here.
All right. Today is the date and time set for a sentencing. There was a plea to operating while intoxicated on February the 12th. We adjourned it for substance abuse assessment, set today's date for the time of sentencing. I have received a outpatient counseling progress report from Basis and Michael Sobolski, who's the counselor. Mr. Rolla, have you had a chance to see that?
Yes, actually, our office has received it. Thank you.
All right. Then as to Mr. Erky, what I'm going to do is let each of the lawyers tell me what they think should happen at sentencing. And I'm going to give you an opportunity to tell me anything that you think I should be aware of as well. I'll start with Mr. Rolla. Your comments, sir?
Yes, thank you. According to the SAS, it indicates the defendant's been diagnosed with alcohol abuse disorder. There's a number of recommendations. I think they should be followed. I would also make sure that the court also includes the restitution to Gaylord City PD in the amount of $345 as requested.
Mr. Brown, your comments and elocution?
Your Honor, we have no objection to that. I believe that will help him. It will help the community. And hopefully this will prevent any more visits to the court by Mr. Erky.
All right, Mr. Erky, is there anything that you want me to be aware of, sir?
Sir, I'm trying to go through court. I'm trying to stop my drinking, and I'm going through counseling to do that.
All right, I'm glad to hear that. Where are you at physically right now, sir?
I'm physically in Elmira. I live in a camper right now because I've had my house burned down twice in 2 years.
All right. The reason I asked the question is it appears that you're laying on a bed. Is there some reason for that?
Yeah, because I'm in a camper, sir. I don't have anywhere else to be. I'm in a travel camper. That's what I live in.
It's just a little unusual to be laying on a bed when you're in the court. So is there some reason why you can't sit up or can't orient yourself appropriately?
I can't sit up because my dog's on my lap. Is that better, sir?
It is. Thank you. Anything else that you want me to be aware of, Mr. Eric?
Ashley, my name is Erky.
All right. Sorry about that, Mr. Erky. Anything else that you want me to be aware of?
I am trying to do better for myself. I am trying to go through counseling and get my life together.
When was the last time you had something to drink?
It was quite a while ago because my gallbladder was removed and they told me if I didn't stop drinking that I was going to die.
That sounds like something that would get your attention pretty quickly.
Yeah, it did. And so I stopped drinking.
Good. I'm glad to hear that. All right,
I was
sir.
just having a bad day that day. And I messed up.
All right. Well, I'm going to give you a chance to make up for it. So let's hope that happens. I'm going to put you on probation for 6 months. There's an oversight fee of $180 for that. There's a crime victim fee of $75, justice assessment of $50, restitution to GPD for $345, court costs of $200, fine of $100, and a local charge of $15. Let me add all that up for you. It's a total of $965. Pay that over probation. And will allow you to perform community service in lieu of some of those fines and costs at the discretion of the probation department. I will require you to enroll in and successfully complete a treatment and educational program. And that would be your outpatient counseling report requirements. Do you have Mr. Cebulski as your counselor, Mr. Erky?
Yes, I do.
All right.
I'm
You're gonna
already
need
in
to. I'm sorry?
I'm already in outpatient counseling.
Good. I just want you to complete that process. So do what your counselor says for as long as he says to do it.
All right.
And then you will need to sign a release so that your counselor can talk with the probation department and make sure that she knows what it is that you're supposed to be doing. So do your outpatient counseling, follow all recommendations, sign a release.
Okay.
While you're on probation, there's to be no consumption of alcohol or possession of alcohol or drugs, no entrance into a business where alcohol is served by the glass. That means no bars. You can go into a restaurant, even if it happens to serve alcohol, but you may not be in the bar portion of the restaurant. You understand the difference between the bar and the restaurant, sir?
Yes, I do.
All right. There will be drug and alcohol testing at the discretion of the probation. I'm going to impose 10 hours of community service work because I want you to give something back to the community for what you've taken by way of this criminal charge. You can find places to work at through the probation department. Typically, they would be at public service agencies or nonprofit organizations. Do you have any questions for the court about what the court has ordered, sir?
No, I don't.
Mr. Brown, anything?
No, Your Honor. Thank you.
Mr. Rolla?
Nothing further. Thank you.
That's all for today then. Thank you very much, Mr. Erky.
All right, thank you.
Court does call the case of the people versus Bowie Jones. We need,
So now we have people, Your Honor.
well, we need him, I think. You all right?
Floor's uneven right now.
Court calls the case of people versus Corey Jones. Basis.
Good afternoon, Your Honor. Edward Lucas on behalf of Corey Jones in 1318.
Good afternoon, Judge James Murray, P 5490, appearing on behalf of Mr. Jones on the subsequent matter.
All right, what are we doing?
Your Honor, today,
Your motion.
great, this is
Go
the eighth time for my motion to withdraw. First of all, I want to apologize for inconvenience of court. If so, I have talked to mom. Well, actually, I was in contact with Mr. Jones's mother for the matter that brother counsel is on now. They were saying me on such matter. In the middle of negotiations for such case, he was arraigned on this new matter. In the rush and the haste of attempting to get off that case to make sure the arraignment went successful, failed to put limited on my appearance for the arraignment purposes. And after discussions with mom, she had decided to go in a different direction. So with that being said, I would ask that my motion.
Oh, but your motion says that the relationship between you and Mr. Jones broke down.
Correct.
Okay, but that's not what you just told me.
So to flesh it out more, I was speaking to Mr. Jones on behalf through his mother. His mother was the one who went through everything. His mother reached out to me. His mother kind of did all the contacts. Mr. Jones has been incarcerated in Washington so far.
I know, but I'm trying to figure out what's the basis of your motion to withdraw.
The basis of the motion is that I was engaged by Mr. Jones's mother prior to the arraignment. She does not want to proceed with me as counsel.
Why didn't you say that in the motion? I guess because all this has done is delay Mr. Jones's matter. I just
understood, Your Honor. I do apologize for the inconvenience.
Well, it's not just apologizing to me, it's Mr. Jones. I mean, I'm trying to, he's got a right to have his matter proceed forth, and now, Mr. Jones, what do you want me to do? You know? My lord. Yeah. Grab that motion. Yes, Senator.
Yes.
Mr. Jurgensen, your matter, what are you doing?
Your Honor, I sort of the tail, the other case is sort of controlling. I'd be asking for an adjournment to follow that case. My case is a fleeing matter. The other matter.
I'm sorry.
Is that just a fleeing case?
Yeah, but you don't have to take the baby out. That's what you're trying to do. I like hearing babies more than I do attorney. You're all right. Okay. Thank you though for having that consideration. You're good.
I believe it's a 15-year max on one of the felonies in the other matter. So I think that I don't have that report. I don't know much about it at this time.
Has the discovery been settled? I mean, where is his case at this point?
I have not received discovery on this matter.
Pardon?
I have not received discovery on this matter.
While our office, I do have the discovery in our file media. But I'm not sure.
He was arraigned on March 2nd. And so nobody's been working on his case since?
The arraignment for, let me just clarify, for the case ending in.
The one you entered an appearance on. He was arraigned on March 2nd. I'm now sitting here a month later and no discovery's been picked up. Nobody's working on his case. Counsel, that's not how law is practiced. Ever. And certainly not here in Washtenaw County. If you were going to withdraw, then you go ahead and you get the evidence. At least then when new counsel steps in, you could turn it over to them. But you don't do this way. You don't do this to Mr. Jones. Have you ever talked to Mr. Jones?
Not directly.
Then why did you lie in your motion?
When I spoke to his mother, she indicated she represents.
Do you have a copy of your motion? Look at paragraph 2.
Okay, I'm here.
Read it out loud. What does it say?
It states that there's been a breakdown of communication between Attorney James Murray and
How is there going to be a breakdown if you never talk to him?
Your Honor, from my perspective, I was speaking to his mother. Expressed Mr. Jones's wishes. I should have outlined that in my motion after discussing that.
Meaning you should have told the truth and had full candor to the court is what you should have had.
I'm explaining exactly what happened right now on the record. I was never attempting to mislead the court. I was speaking to.
No, you did mislead this court. You are making me, when I look at this motion, it appears that what has gone on is you and Mr. Jones are having communication, and for whatever reason, there becomes this irreconcilable thing between the two of you where you can't represent him. That's not it. You never talked to him. And now he's a month out from the time that he's arraigned, and you never talked to him. You shouldn't practice criminal defense anywhere. Because your primary obligation is to your client, not his family, to him. Mr. Jones, what do you want me to do? It's your case. It's your life. What do you want me to do?
What do you mean? Like, as far as what?
I know you got Mr. Drukas on that one, but do you want him representing you? For you, Mr. Jones, I'm going to grant the motion to allow him to withdraw because he hasn't done a darn thing for you. Don't come back into this county until you're ready to practice like you should practice. Goodbye. Goodbye. I dare you to slam that door. I'm calm. I'm good. This Gaines, on this case, I think he stepped in or did whatever he did, but he I don't think the PD was ever appointed. And I don't know. I mean, I want to get his case moving along because if
If the public defenders is appointed, we can get that discovery over to them. So it was such an appearance for everyone. Get that over to them, public stairs tomorrow, that would be hard to document, police court, media, not one of all the files.
all in, okay. And
We could adjourn
the only
when
thing that I'm worried about is you're on this other case.
I'm on the other.
Because of a conflict with the PD,
Correct.
right? I'm just trying to make sure, is there going to be the same conflict? Because then we can try to skip that step. I mean, it sounds crazy, but skip that step to get somebody appointed that's going to represent him and talk to him about the case he's on.
Let me see if I can check right now.
Okay. Oh, bring the baby back. See, that's upset. He took the only person I liked in the courtroom out. What, are you worried that she's talking too loud? Are you? Don't really, I'm serious. Don't worry about it. If she's got something to say, well, I'm going to let her say it and we'll just all wait.
Nicolette. Oh, Mr. Jones. Okay.
Are they down in the back office? I think if they have a conflict, they have to figure out some way to do that and then get.
Typically comes.
Right, yeah, exactly, but I think what I need to do is appoint the PD first, then get the order withdrawal and appointing you, since I don't do the appointment, but. Okay, tell them, are they hearing it? They probably, I don't have them on.
No, they're not.
Can you let them know that on Mr. Jones' case that and tell them which one it is, and that Mr. Drukas has his other case. And we're not sure whether the PD has a conflict. Mr. Jones, I apologize to you. This is not the way it's supposed to happen, but I didn't do it, but we're going to try to make it as right as we can. All right. No, I just say I just say that.
Based on Mr. Gaddy's look, I think we will likely have a conflict on this matter.
On this one.
Yes.
Okay, then let's the approval chain to appoint counsel for him. Can you do that, Ms. Gaines? Can do that? Okay, so here's what I'm gonna do. This is gonna sound really weird. But I'm going to appoint the public defender The public defender will then have a conflict. I then need an order from the MAC office.
I can,
And maybe I don't have to wait for the paperwork. Can you ask them that if the PD has a conflict, which it looks like they do, they'll get that? Will they be appointing Mr. Drukas? Because then I can proceed with this matter and we can go and we'll just follow up on the paperwork.
Mr. Drews, wanting to make sure that discovery gets to them tomorrow.
I'd ask for the week adjournment so I can review discovery if it does come to
See
me,
where-
and then we can come.
I just can't appoint you myself.
Yeah.
And so I have to wait from a verification from them that that's what they're gonna do. To who? She doesn't have an answer yet. She should have an answer already. Type in this. Judge wants to know what's taking so long. Thanks. Well, I think here's what I do, since it's a PD case at this point, I'm just going to adjourn both cases out to the 9th. We'll just make sure to follow up today with all of the paperwork. Okay, on that. So I'll adjourn both cases, probable cause conference, April 9th, 2026, 9 a.m. Bond will continue in both cases. All right, Mr. Jones, you understand kind of what's going on?
Yeah.
Got it. So one of two things will happen. It's likely that there's a conflict there, and so that you'll have Mr. Drukas for both of your cases. Okay. If not, worst case scenario, you'll have Mr. Drukas, you'll have the public defender on the case. But you got an attorney that's going to represent you. Okay. All right. We'll see you next.
The council was wanting to send the appearance direct, so we know who to send it to.
Right. Okay. They'll make sure. All right. Thank you.
Thank you, Your Honor.
That's it.
And don't you come back to Washtenaw County until you're ready to represent our clients properly. Ladies and gentlemen. Wow. You don't often see stuff like that, do you? What we got going on over here? Auntie, Trishy, Julie, Becky, D, Kiernoth, P, and Northwest. You know, X25, thank you so much for that donation. That was awesome. Eating the unruly PDs and eating is good. Oh my dear Lord. Chat has been amazing tonight. Mama Wolfie is right. Julie Sassy, thank you so much for hanging out with us tonight. Beck, thank you hanging out. Everybody that's lurking out there, thank you for hanging out. And I do want to let you know, in case you haven't already heard, we're going to be doing a little, one of those redirect things. And that's what the URL looks like to the next live that's happening right now. As the music ends on this channel, there's content already fully in progress on another channel. with our friend Huck. That's right, he's doing a late night, ladies and gentlemen, and we're gonna send the crew that wants to go over there. I'm not even looking at the camera. I don't know. I've had the puppies all over me all night long. It's been one of those days, you know. So hang out, give Hutch a raid, tell him I said hello, and you know, come on by tomorrow, and we'll have one more day of the. Oh my God, April has begun. One more day of the first week of April. Oh, and you know, the first Friday of the week in Judge Middleton is always kind of crazy. So, ladies and gentlemen, we might have a Middleton tomorrow. I don't know. We'll just have to see. We've got a big Saturday planned already. So make sure you come out for Saturday brunch, 11 a.m. Central Time, 12 p.m. Eastern. And we will have some fun things to watch and drink some coffee together and chat about some court. That's what we do. Thank you, everybody, for coming out. I am your Lone Wolf Oozle. I'm your host for these here little get-togethers. I am your curator here at the channel. And oh my goodness, Becky, thank you so much. Holy crap. Let me give that a little heart right there. You just sliding that right on in very end. Oh my goodness, that was amazing. Becky, hang around. Go tell Hutch I said hello. Thank you so much. I can't say thank you enough. The puppies thank you. The stream boss is actually right there. Can't tell, but he is. He's right there. He thanks. He actually just looked around and said, did one of those little trill things. You know? I got to do this. Oh my dear Lord, that was amazing. Y'all have a great night. Tell Hutch I said hi. I'm out of here, guys. It's been great. See you next time. Really? That's not what I wanted. Oh. My face is not even on the screen. What the heck is going on right now? You can hear me talking and you can't even see my face. This just goes to prove. When you sit and think to yourself how stupid most people are, just realize that most of them are even stupider, including me. Have a great night.